Good morning, everyone. Welcome to Workers' Compensation 101. This is the Department of Workforce Services virtual training series, and this is our 4th month of doing this. My name is Erin Turbett, and I'm the communications lead for the Department of Workforce Services. I hope your week is off to a really great start, and I am so excited to welcome you to this 4th session. We have specifically chosen key topics, including today's, to share with you based on feedback from a customer survey our agency conducted back in July of 2023. Using those results, we identified various topics to provide free virtual training each month. To learn more about what other presentations we will be offering throughout the year, please visit our virtual training series calendar to register. And somebody is putting that up in the chat right now. So you can take a look at that if you would like. In today's presentation, we have the honor of hosting 2 of DWS's experts on the topic of workers' compensation. Erica Pasco is the customer service advocate for workers' compensation, and she's been with the Department of Workforce Services for 12 years. She started as a claims analyst and moved to her position as the customer service advocate in 2021. She's lived in Wyoming since 2001 and has been with the state since 2012. Maria Barker has been with the Department of Workforce Services for almost 26 years, starting in the intake unit and moving to provider services, and then to employer services as an accounts receivable specialist. She became the Employer Services Manager in May of 2022 and was born in Colorado, but has lived in Wyoming since 1981. She's married and has 2 children, 1 granddaughter, and 2 dogs. During today's presentation, you'll learn all about workers' compensation. And I have made a little bit of an error here and messed up my notes. So I'm going to check those real quick. Sorry about that, guys. Okay, so this is going to be something that every business owner or employer is going to want to see. This the first half will be covering workers' compensation, which includes employer registration and when you need to report an injury, the injury reporting process, including how to file a claim, compensability review, that's a tough word for me, compensability review, temporary total disability, and light duty. The second half hour is an introduction to workers' compensation employer services. This covers when and how to register your business, out-of-state employer information, extraterritorial coverage, how to report and pay premiums, and certificates of good standing. Thank you, everybody, for coming again. Thank you. And if you have questions throughout the presentation, please feel free to submit your questions in the chat. We're going to keep track of them throughout. And throughout each section, rather. The first half will be Erica Pasco, and once she's done with her presentation, we'll ask questions about that part of it. And the second session, we'll ask questions at the end. So thank you, everybody, and thank you, Erica and Maria. Let's go ahead and get started.
Okay. Thank you, Erin, for the introduction. My name is Erica Pasco, and as Erin mentioned, I am the customer service advocate for Wyoming Workers' Compensation. I am going to be doing a presentation regarding the claims side of workers' compensation. So with workers' compensation, we are governed by state statutes and rules and regulations. The statute that workers' compensation will fall under is Title 27, Chapter 14. Here is how workplace injuries all work. The main statutory definition of an injury is going to be any harmful change to the human body other than normal aging. This is the main statute that workers' compensation is going to rely on. When you are reporting a workplace injury, the injured worker has 72 hours to report the injury to their supervisor. After it's reported to their supervisor, the injured worker and employer can work together to complete the injury report. That does need to be filed within 10 days of the injury. And this is 10 calendar days, not 10 business days. Injuries that are reported outside of these timeframes usually will require a written explanation as to why it is delayed in being reported. Once the injuries report has been filed with the division, an analyst will be in contact with the employee and the employer within 5 days of the initial claim. This yet again is 5 calendar days, not 5 business days. If it has been longer than 5 days since you believe the report should have been submitted to us, we highly encourage you to contact the division to make sure that we have received that report. Once we receive the report, the analyst is going to do their initial review. They're going to look through the injury report, make their contacts, and determine if there's any additional information that they're going to need. At that point in time, they will send out a letter of information if they do need additional facts, such as medical records or statements. If it was a late file, the late file reason, anything the analyst might need to make a determination on that claim. They do have 60 days from the date that the claim was submitted with us to make a final determination. To determine compensability after the analyst completes the review, they're either going to send out a letter to accept the claim or send out a letter to deny the claim if they are not able to open it for benefits. The denials can vary based on claim to claim situations, so not every denial is going to be the same reason. Some of the benefits available for the injured worker once a claim has been accepted for coverage. Of course, the first one's going to be medical care. The division will cover medical treatment that's directly related to the work injury. We are going to review any bill submitted for compensability, anything that is reasonable, necessary, appropriate treatment to the injury. There is instances where a bill might be covered for a one-time medical test, something that might need to be considered as a rollout on the claim. But workers' compensation does not direct medical care. The injured worker and the provider should be working together to decide what the treatment plan should be, any appropriate medical services. We are not able to decide who your physician should be. That is something that the injured worker would have to pick on their own. The only service that does have a pre-authorization process is surgeries. The provider can submit a pre-authorization for surgery along with the necessary documentation, medical records, anything else that's required. And any of these documents, the pre-authorization forms, can be found on our website. Additional benefits for the injured worker also are mileage reimbursement. If you're having to travel more than 10 miles one direction for medical treatment, and that is the closest provider to you for that specialty, we can reimburse mileage. We do go off of the federal rates for mileage reimbursement. And if you've had to pay for a prescription or a medical visit prior to your claim number being provided to you, we can reimburse for those first costs. After that, the claim number does need to be provided to your treating physician or anybody else that you seek treatment with, and any pharmacies for any related prescriptions. We are not able to reimburse any copays. So if you do see a provider for the first time and you provide your personal insurance and have to pay a copay, those costs are not able to be reimbursed. Medical treatment will continue to be covered on the claim as long as it's reasonable and necessary and related to the claim. If there is no activity on a claim after a 6-month period of time, it will auto close. If after that period of time we do receive a bill for treatment on that claim, the analyst will review for relatedness and to determine if we can reopen the claim. If it's been more than 4 years that the claim has been closed, they can be a little bit more difficult to reopen at that time, and the analyst will be required to send additional information. You would get a letter with the specifics as to what needs to be provided for us to review to reopen your claim. For any indemnity benefits, this would be starting with temporary total disability benefits. This would be a benefit that the injured worker would be eligible for if they're going to be missing time from work. To be eligible for this benefit, you need to be missing more than 3 consecutive days of work and have a doctor that is signing you off of work. There is an application that needs to be completed for this. Temporary total disability benefits do have a cap of 24 months. There are circumstances that could extend it past that 24 months, and at that time, an extraordinary application would need to be completed and reviewed. Temporary total disability benefits are paid at 2/3 of what the injured worker's gross monthly wage is. Usually to calculate those wages, we do ask for pay stubs to get an average of what their monthly wage is if their wage varies month to month. And these payments are made twice a month. The first payment is usually made around the middle of the month, and the second payment is made around the end of the month. The division does apply these payments to a debit card, which is supplied to the injured worker, or there is the option for electronic funds transfer if they want to choose that option instead. And this is a registration process through the state auditor's office. If the division does get a court order showing that child support is being withheld for the injured worker, we are required to withhold those wages, as those payments as well from the wages. And you cannot be getting unemployment at the same time that you are getting workers' compensation benefits. You should also be in contact with your analyst at least once a month to get updates as to how your medical treatment is going and what the plan of care is. If for some reason you are able to work light duty, we do have the option to do a light duty contract with your employer. This is something that the division will reach out to the employer to establish. There is a contract for this. To be eligible for light duty, obviously you need to be cleared by your physician. And light duty would have to be an option with your employer as well. The time frame for light duty work, it cannot extend more than a year, and that does count towards the 24 months of the temporary total disability benefits. The way that payment would work for light duty is the division would receive at the end of the month the payment made to you from your employer, and we would be able to compensate 80% of the difference from what the normal gross monthly payment is. So these payments are only made once a month at the end of the month. Any payments made to an injured worker while they are on light duty is not chargeable to the employer's account. This is an example of what the contract looks like. The first page is the offer from the employer. They're going to fill out this portion of it. They're going to sign the bottom part of it. Then this contract is going to go to the provider. They're going to list any limitations that the employee has. Then they're going to note the date that they feel like the employee will be released to full duty. And then they're going to sign saying that they agree with what the employer is offering as far as restrictions for the injured worker. At that time, then the employee either has the option to accept or refuse the light duty contract. If they do refuse the light duty contract, their benefits will be reduced to 1/3 of their monthly benefit instead of the 2/3. If there is an injury that does result in a death, we do offer death benefits, and these would be payable to a spouse, a dependent minor, or a dependent parent. Applications must be submitted for these benefits, and they're payable for 100 months at a time. In contested cases, this is the last subject I'm going to go over. This is if anything is submitted that anybody disagrees with the final determination that they have received. So any approval or denial of benefits does result in the division issuing a final determination. This is a letter provided in mail to the employer, the injured worker, or a provider if it's regarding medical benefits. It will have the reason for the denial, or it will show the approval of the benefits. Any of those parties do have the option to dispute our determinations. If anybody wants to object to a determination, there is a 15-day time period to respond to that letter. And response does need to be made directly to the division to go through the hearing process. If the division has received the response later than that 15-day time period, you will get a letter letting you know that your objection was late, and it will have another response period that you can respond to, which in that instance, the issue would go to an internal hearing. The division does cover attorney costs for any injured workers, no matter what the outcome of the hearing is. If an employer is objecting to a final determination, they are required to cover their own attorney costs at that time. If an employer is objecting to our initial letter opening a claim for compensability, if there is a lost time with that claim, temporary total disability benefits would only be paid for the first 90 days. And medical bills would not be paid until the litigation is resolved. If the issue at hearing is regarding coverage of any kind of medical treatment, any bills related to that specific treatment would not be paid until the litigation is resolved as well. And medical providers do have the right to request alternate payment during that time. So they do have the right to ask for your personal insurance to run those claims through, or personal pay if they choose to do so. That is the end of my presentation. Are there any questions regarding the claims portion of things?
Erica, we do have several questions. This is great. I'll go ahead and read these out to you. First, does the employer have visibility to see when a claim has been closed and then reopened?
Through our Peers website, and that's Peers, PIERS.wyo.gov, they can run a lost run report on that, and that would show the status of any claim at that period of time. They're not going to be notified if a claim is reopened, but they can see the claim status on that website.
Our next question is total temporary disability taxable income for the employee?
It is not. You will never receive a notice from the division as to what we have paid you in temporary total disability benefits, and it does not need to be claimed on a tax return.
Good. Next, does an employer have to accommodate light duty for up to a year?
The employer doesn't have any responsibility necessary to accommodate light duty. This is just a benefit that is offered, and it is something that would be non-chargeable at that time for the employer. But if they are not able to have something available for the injured worker, they are not required to do so.
Okay. Next, do we have to use the light duty contract that you are presenting? Or if we have, as a company, have a form or letter capturing the same data, is that acceptable?
If the division is going to be compensating the injured worker for the portion of their wages that the employer is not covering, that light duty does need to be completed and filed with the division. We have to have it on our form.
All right. If an employee works light duty but at reduced wages, is the employee entitled to wage differential?
That is not something that workers' compensation can speak on. Unfortunately, that would be according to the employer's policies. If they choose to compensate the employee for any additional benefits, that is something that would have to be in their policy and not ours.
Okay. Are there temporary partial disability benefits in Wyoming?
So obviously the temporary total disability benefits, if they're losing more than 3 consecutive days, that would be able to be covered by workers' compensation if the claim is closed. And then if there's light duty available, that would be the temporary partial.
Okay. Does it make employer fees go up if they have workers' comp claims?
That is a little more for our risk management department. They do a presentation regarding loss runs. It probably is going to be on a case-to-case basis, and it's going to matter on what is paid on the claim as to how that's going to impact their employer monthly rating.
And I'll just say right here, we did do the risk management presentation last month. Everybody, you can check that out on our website. It is available for rewatching as well as the presentation. Okay, and back to our questions. Does the employee have a choice in having a claim filed or not?
Yes, all injuries, they don't absolutely have to be filed with us. It's definitely recommended that any injury at the workplace does get filed with us. But if they refuse to want to report an injury, an employer could ask for that in writing so that they would have that if there was any circumstances that arise from that injury not being reported.
Our next question, are you aware of any cases in the past where the employee as an independent contractor did not have workers' compensation and was injured on the oil field job and subsequently were able to still have the employer file a claim? Second part of that question is, or is the employee needing to just hire an attorney?
In that instance, I probably would recommend for the employee to discuss this with an attorney. I couldn't speak on specifics in that case. We do run into the issue where some employees are considered independent contractors and might not be covered under an employer's coverage. But anything in that aspect, it's all going to be reviewed on a case-to-case basis.
Next question. How do we as an employer get a workers' compensation certificate to provide to vendors?
I do believe that that is something that Maria is going to go over in her presentation. There is a link on our website to be able to obtain a certificate of good standing, and I think Maria is going to go into more details on that.
Okay. Next question. My company has a robust return to work program across the country. How can we best partner with the state to ensure the adjuster is aware of our ability to accommodate work restrictions?
I believe that's something that you could definitely let your analyst know at the first line of contact. An analyst is always open for any information that the employer is able to provide to them, anything that you want to disclose. I would just recommend constant contact with the analyst if you need to get updated work restrictions so that you can let the analyst know if you can accommodate light duty for that injured worker.
Okay. And then next question, if a claim goes to litigation and the treating physician requests payment from personal insurance, is the employee reimbursed or is the personal insurance reimbursed?
After the hearing process is over, if the issue at hearing is something that the division is going to cover, those medical bills can be submitted to us and we will pay according to our fee schedule. After the provider receives payment from us, the injured worker should be able to get reimbursement from the provider's office if they had to pay personally for that, or their insurance should be getting reimbursed at that point in time as well from the provider's office.
Okay. And it looks like we have just one more question. If a person is injured as a tow truck driver and the company does not carry workers' comp, is there anything that can be done?
With workers' compensation at that point in time, unfortunately, no, there is nothing further that can be done. They would have to contact their employer to see if they have coverage through another third-party company or something to that aspect. Or they could seek a third-party litigation, talk to an attorney if they want to, but workers' compensation would not be able to do anything further if the employer does not have coverage.
Okay. And we did get another question. If we are a Wyoming-based company, but have remote employees living out of state, will Wyoming workers' comp accept their injury reports, or should we also be covered by workers' comp in their state?
Is this something that you're going to go over, Lowell?
Not with injuries, but
Not with injuries,
with coverage, yeah.
So if you are, if the wages are being reported to the state of Wyoming and the employer has coverage with us, that injury could be covered by us. It's all going to depend on where the injured worker's wages are being reported to.
All right, if there are no further questions for Erica, we can move on to Maria. All right, let's go ahead, Maria. Thank you. Thank you, Erica.
Thanks, Erin.
Thanks, Erin. So I'm Maria Barker, the Employer Services Manager, and I'm gonna go over the basics for employer services. Okay, so this is our main question. How do I know if I need to register for Wyoming workers' compensation coverage? So extra hazardous industries are required to have workers' compensation coverage. All non-hazardous businesses may elect to have coverage, but are not required. The registration process. So here is the website where you will register. And the online registration will register you for workers' comp and unemployment. Registrations will be reviewed and determined if the business is extra hazardous or non-hazardous. Out-of-state employers. All out-of-state employers that are working in Wyoming will need to register at the website. If you're permanently working in Wyoming, we can use that registration to determine if you need a Wyoming workers' compensation policy or not. If you are required to carry work comp coverage, you'll need to provide a bond to activate your coverage. And with that, if your wages, your total wages are under $4,000, then you will not need to provide a bond. If you're not required to carry work comp coverage, proof of coverage from your current carrier will be required. And if you are temporarily working in Wyoming and not employing residents, we can use the registration and proof of coverage to issue you a certificate of good standing. So here's kind of a flow chart that'll help determine reporting and coverage. I know it's a lot to read right now, but this will be on our website. And it's a good reference. If you're not sure if you should report your employees here or if you're in another state, it's a really good spreadsheet. Certificate of good standing. A certificate of good standing from Wyoming Work Comp will verify to a third party that your business is in compliance with all the statutory requirements and that your employees are authorized to work within this state. To obtain a cert of good standing, employers must be current on all workers' comp registration requirements and premium payments and reporting requirements. A certificate of good standing can be requested through our COGS website. And if you cannot produce one from the COGS website, you can email us and someone will reach out to you. Extraterritorial coverage. So for extraterritorial coverage, it's a reciprocity of coverage between different states. And at this time, the state of Wyoming has reciprocity of coverage with Utah, Colorado, Oregon, Nevada, North Dakota, South Dakota, Ohio, Montana, Washington, Idaho, and California. If you're a Wyoming employer going to any of these states, please contact us for an extraterritorial certificate. If you're a Wyoming employer and you're going outside of the states listed, please contact that state for their workers' comp requirements. If you're an employer from any of these states temporarily working in Wyoming, we will accept your extraterritorial certificate from that state. For extraterritorial certificates or questions, you can email the DWS CERT email. Payments and reporting. As an employer with an active work comp policy, quarterly reports must be filed. These reports inform the division of the employees that should be covered under your policy and the payroll amount used to calculate the premium. As a courtesy to our policyholders, employer with an active work comp policy and an active unemployment insurance policy may request to have their accounts joint. With the joint workers' comp and unemployment insurance policy, employers can report and pay premiums online using the website. Summary reports and wage lists. So a paper summary report and wage list will be used for non-joint filers. So if you decide you do not want to file joint with unemployment, then you'll have to submit a summary report and wage list on paper. The summary reports are used to submit total wages and tax information, and it is gross wages. A wage listing and report of individual employees and information and wages. Employers are required to file a new summary report and wage list for every reporting period. So if you have no employees for that quarter, you will still be required to file a zero report to be in compliance. Reporting dates and delinquencies. So here's a chart of all the dates that the reports are due. When it gets to past due, you will be charged 1% a month. And then when it gets to the late filing penalty, that is $100, a one-time charge. And that's all I have. And there is contact information for the division and for myself.
Thank you, Maria. Does anybody have any questions for Maria? I know there was a question earlier about certificates of good standing. Did Maria's presentation answer that question for you? We're good. I think we're good. Did another one just pop up though? Okay. For workers' compensation wage reporting, is it gross/total wages or gross minus health insurance deductions?
So it'd be gross total wages.
Okay. Very good. Any other questions? I don't think, I'm not seeing any other questions pop through. This has been really an amazing presentation and really good back and forth between the audience. I really appreciate the audience and our speakers, Maria and Erica. Thank you so very, very much. Let's see. So this afternoon, we will be sending a follow-up email with, it's going to include the link to this presentation on our website. It will also include today's recorded presentation and the slideshow as well. We're also going to post a quick link, 5-question feedback survey, and we would love it if you would fill out that survey. It shouldn't take you more than probably 3 minutes. We want to make sure that we're hitting the mark with these presentations for you. So if you can take a couple of minutes to do that, we'd really, really appreciate it. Oh, we have a question. We have a question that came through. Do you have to create an employer login to access the loss run?
Yes.
If they want to do it through the Pierce website, yes.
Okay. What if is that the only way to do that?
They can email our risk department as well. There's contact information on the website, and the risk department can run a loss run report for them. Otherwise, they can create a login to the Pierce website and run it themselves.
Okay, perfect. And then looks like the last one. Oh, not the last one. What info do we need to get the certificate of good standing?
So we just need the name of your business, and then we look it up in our system to see if you're in compliance.
Okay. Oh my goodness, we've got a lot of questions coming in now. Okay. If a contractor needs to, hold on. If a contractor needs to request an ET letter, I'm not sure what that is. Do you guys know what that, you know
Yes.
what that is? Okay. If a contractor needs to request an ET letter, should they start with their home state or the Wyoming Workers' Comp office?
If they're an out-of-state employer, they should start with their home state.
Okay. And what is the website to file the workers' compensation claim?
If they're talking about a report of injury, we do not have a website that those can be reported through. The injury report itself has the options for how to file that. On the second page of the form at the bottom left-hand corner, there's an email address that it can be sent to. There is a fax number or our physical mailing address.
I did
Okay.
want to bring up your information again.
Okay. And then what is the website to file the workers' comp return?
What do you mean, return?
I do not know.
I think it's the wages. Where do they report wages?
Okay.
So, yeah, that website was this wyui.wyo.gov.
Okay. What direction for troubling the COGS site if it will not let us move beyond step 3?
So that's when you'd want to send us an email, because we do have that issue quite a bit. So send an email to the DWS-WC cert, and then somebody will reach out to you or get one for you.
Okay. And then it looks like our last question, will there be a certificate of completion sent to all? We just had that question come up a couple of days ago and we had not thought of it before, but we will be moving forward with that. And I am hoping to get that sent out with everything this afternoon. So yes, you will get a certificate of attendance for this presentation. And if there are no further questions, thank you so much. This has been a really fabulous presentation. Thank you, audience. Thank you, Maria and Erica. Thank you. Thank you very, very much.
Thank you.
Oh, we have one more question, sorry. Are these webinars PHR SHRM pre-approved? Yvonne, I might.
Yeah, Erin, I don't know that we've worked with, SHRM. That's something that we can look into.
Okay, we'll look into that. We'll look into that for you and see what we can find out. And then, is there a certificate available for last month's session? Yes, I'll go ahead when we do this month's, I'll go ahead and resend, I'll send certificates to everyone who has done the last 3 presentations, in fact. So, well, yes, the last 3, including this one, so 4. So, thank you, everybody. Really
Erin, I'll
appreciate
just
your time
mention,
today.
I did put a link in the chat as well to register for the next session if people want to. And I posted a few times the link to take our survey, as Erin mentioned too, just so that we can get that feedback on how today went.
All right. Okay, thank you so much, everybody. We really appreciate your time today, and we're looking forward to seeing you next time on May 7th. Thank you so much. Bye-bye.